I imagine that everybody here has some experience with tenants. Yeah, you're in a landlord group, so you probably have some kind of experience with tenants. How many of you have ever had a bad experience with a tenant? Okay, so not all of you. I didn't see all hands go up, but I can tell you this about anything you do that involves other people. You will have bad experiences. That just happens, and it's not necessarily because they intend to be bad, or that they started off with any kind of malice in their hearts, like, I'm gonna get this landlord. That's not typical at all. In fact, most of the time, we start off with the best of intentions, both tenant and landlord, but sometimes real life happens and things go wrong, whether that's, again, by virtue of a mistake that someone made, or by something that happened to them, and now they're responding to just a bad situation. And sometimes they'll respond well, and sometimes they just won't. And we can't control how the tenant responds. We can only respond in our own way to suit our own business needs. So I want to talk a little bit about the process of management that could ultimately result in an eviction, and then ultimately what to do post-eviction. Because if you've handled your own eviction before, you might have money that's just waiting to be collected. And so I want to show you even how it is still possible, even years later, to collect some of that money. The first step that I want to go through is violation. The lease itself should be pretty clear. The lease should establish what your expectations are and what their expectations are for how the tenancy is supposed to be enjoyed. But I'll tell you that most people believe that trouble begins at violation. That once there is a breach, once there is a violation, that's the beginning of the trouble. But I beg to argue that actually the problem started much sooner than that. It started before the lease was ever signed. Because we sometimes run head first into a lease without really thinking about it. Maybe we didn't screen with as much depth as we could have. And maybe we didn't have a proper conversation with our tenant before, because we were so excited about money and we finally found a tenant and it sat on the market for 2 months. And yes, we got someone who's willing to pay and ready to sign and eager to move in. And that kind of clouds our judgment sometimes. And it's sometimes these steps that ultimately lead to the violation itself. Again, not intentionally, not as a direct cause, but as one of the links in that causal chain that, had it been handled differently, might not have resulted in a violation at all. But what am I talking about? Well, so one thing that I strongly encourage, and I hope all of you do this before you ever hand over the keys, because we're so eager, it's like we just want to give them away. Once we've got someone who's interested, we want to take these and put them in their hands. Say, take that house. I want you there. I want you there because I want your money. And sometimes we're so eager to hand over keys, we don't bother to square away things like the security deposit. And so certainly those keys should not leave your possession if you haven't gotten the full amount of that security deposit, if you haven't gotten an actual signed lease, if you haven't seen the tenant. This seems like an obvious one. You gotta see the tenant, but so many landlords hand over the keys sight unseen. And they'll do everything digitally. And man, we're big on digital transactions right now. But there is something to the old-fashioned way that still makes a lot of sense. If the only copy, for example, of a person's ID you've ever seen is a digital copy, there should be an alarm bell going off in your mind. That before you hand over those keys, you want somebody to pull out their wallet and show you their ID, right? Remember, that at the time you're handing over keys, you're physically in front of, and maybe it's not you, maybe it's your property manager, maybe it's an agent, but you want them to make that determination. This is the actual person, and their digital ID matches up with their physical ID, because that's not always the case. People create fraudulent documents all the time, like W-2 forms. It happens all the time. People will submit forms that they made on their own computer. It's not hard. It's very easy to make up fake bank statements, fake tax documents, fake payroll. And so we're taking these things at face value and not picking up a telephone and independently verifying that this person, number one, exists, number two, actually is employed, and number three, makes the amount of money they claim they're making. We're not taking diligent steps to confirm these simple things. Again, you're going old school by picking up a telephone and actually calling somebody, but it's worth that a couple extra minutes could save you thousands of dollars of headache. Because I'm telling you, if you call and you hear, beep, doop, beep, the number you've dialed is totally fake. Why are you calling? Yeah?
I have a question. So are you allowed to ask how much money they are making? Because I got a few employers that are telling me that they are not allowed to tell me that and to confirm how much money the tenant is making.
So if the tenant discloses to you, I make 3 times the rent, right?
Yes.
Or more,
Yes.
and you know that your rent is $2,000. Is it a secret to say, I just want to confirm my tenant has applied and said they make at least $6,000? I don't even know the exact number, but do they make $6,000 or more dollars? Is that an accurate statement? That's a yes or no. That doesn't have to be specific, but it does have to be confirmed. If they can't confirm it, then you tell that applicant, I'm sorry, I could not confirm your employment, or I couldn't confirm your salary. So on that basis, can't do it. And so it's important to be able to do it. And the prospective tenant can always authorize their employer and say, look, hey, they called me yesterday.
I get them to sign a form and I fax it to the employer.
That's exactly right. And as part of your application, you can get this authorization and you can send it over to the employer and say, look, this is something they want, this is something they've asked for, I'm just confirming it. And they say, well, I don't feel comfortable. Okay, that's fine. I don't feel comfortable then handing over those keys, right? Right, those keys. I gotta feel real good about it before I do it, because that's $2, $3, $4, sometimes $500,000 worth of risk. Not worth it for a maybe. It just isn't. Remember, so many of these violations could have been prevented with a phone call. Could have been prevented by a phone call. You know, I've had too many times where people come to me and say, Ernie, I can't believe this. I can't believe they had such a glowing recommendation from their realtor. How could their realtor have lied to me? Is that legal? Well, first of all, fraud is never legal, but that realtor maybe didn't know them personally. Sometimes they do, and sometimes they perpetuate the fraud. That's a different thing. But you can't take the opposing side's, word for it. You have to verify. And if you're not taking these steps, you are essentially complicit in the future violation. Now, you do everything you can to prevent violation, then you're likely going to save yourself money and headaches from a tenant who won't violate. In fact, if a tenant is clear, they're likelier to follow your rules, to follow your expectations, to meet those expectations. Does anybody here have children? Does anybody here have children? Have any of you ever said to your children, go clean your room? And they walk away, and then they come back and say, yep, I'm done. And then you walk in and say, no, you are not done. Unless you are explicit with children, they're unlikely to have in mind what you mean. So, I didn't know you meant all of the laundry. I leave it there because it's helpful for me, they might tell you. I know exactly where all my shorts are, my socks and underwear. They're perfectly placed where I like them. But we might have a different idea of what it means for all of the laundry to be organized. And so we tell them, no clothing goes on the floor. All of your stuff should go put away neatly. I shouldn't see trash anywhere. Go take care of that and then come back and we'll talk about you being done with those chores. The same is true even with adults. If you say, tenant, I want you to be a good tenant, I guarantee you, they have no idea what you actually mean. In their mind, they have an idea of what it means to be a good tenant, and they may think they're great tenants. But in your mind, you're thinking, well, you didn't do any of the things I expected you to do. But if that expectation was never expressed, how could they? So again, we sometimes have a bit of culpability when it comes to these violations because we're not explicit. Make sure before those keys are ever handed that you're sitting down, you're having a talk. This is before you sign, this is before you accept a deposit, definitely before those keys leave your hand, you're having a sit down with your tenant. And you say, look, I know it's never gonna happen, but if it turns out that rent is not received by day 7 or whatever your line in the sand is, if rent's not received by that day, I'm gonna issue a notice to vacate. Certain it's never gonna be an issue, but I just want you to know this is what I do. It is my policy. Or if you have a management company, an LLC, you say it's the company, and not mine, it's the company's policy to issue a notice to vacate, and so sometimes it helps to have a bit of distance. It's like, I'm on your side, but that company, they're strict, right? And so sometimes it helps, and that's a different topic for a different day. But you have the talk. You say that's the policy. 7 days, and a notice to vacate comes out, and you consistently deliver on that policy. Or you might say, look, if stuff's broken, and like I don't remember this thing being wobbly. In fact, I'm certain that it wasn't. But now that it is, I'm gonna tell you, it looks like this is normal wear and tear. I got it. I'm gonna fix it. Right? That hole in the roof, I know that wasn't you. I got it. I'm gonna fix it. But the hole in the wall, that's not normal. That's not ordinary use. I'm gonna fix it, but I'm gonna issue a bill, and I expect prompt payment. And so part of that sit-down talk is letting them know in the event that you, by negligence or by abnormal use or unnormal wear and tear, cause harm to the property, I will go and fix it. I had somebody ask me, hey, Ernie, I want my lease to always say, you break it, you fix it. And he thought it was a great idea. And in a lot of ways, it makes some sense. But I told him, the problem with that policy is if they fix it, they're likely gonna fix it the cheapest way possible with the worst possible materials and the least qualified workmanship. Why would you entrust anybody with your most valuable asset? Don't do that. Let them know if it's broken, I will come and remedy it, but you're gonna pay, all right? Certain it's never gonna happen, it's definitely never gonna happen. But in the event that it might, here in our talk, I'm gonna address it. And then finally, you want to establish before you hand over those keys that you're gonna be back. Let them know, hey, look, I like to visit the property routinely. In fact, I'd like to schedule the first visit with you right now. Let's say I come on Thursday, the 20th of this month, and their jaw hits the table. What? No, I don't want you in my home once I'm no, That should also be a, because while it is their home, it's your house, right? It can be both, right? They live there and that's true, but your lease probably already has a clause in it. If you use the Texas Realtors lease, section 14, subsection B, and it's a popular section that most landlords don't get right. You have the right to enter as long as it's peaceful and reasonable time. You can go, even without notice. I don't recommend that. I recommend give some forewarning, 24, 48 hours, something, unless it's an emergency. But give some notice, just not asking permission, letting them know you're coming. You don't have to ask permission if the lease already says you have the right to do it. But let them know you're going to do it. Because so many times, a landlord will show up and it's a total shock to the tenant. that they would ever come. Well, I'm just going to inspect. No, I didn't call you. I didn't request a repair. Why are you here? Well, I want to inspect Section 14B. Ernie talked about it. I'm like, no, that's not happening. Sorry. Door shut, locked. You're not coming in. And so if you had that talk before you handed over the keys, if you had that talk, chances are they would have expressed that deep concern and they would have told you, no, I will not allow that. Then you say, well, pleasure knowing you. I will not allow this lease to go forward unless it's clearly understood that I have access to my property, even just to inspect. I'm only going to come a couple times a year. But if you're saying no, then so am I. Deal's off, right? No signature, no deposit, no keys, right? But you're getting ahead of the game and not being shocked when they slam the door in your face and now, well, then I'm just going to issue a lease violation. Sure, but you really could have had a better pick because there were probably 2 or 3 other perfectly viable candidates that you said no to because you chose the one who wasn't gonna go 100%, right? And so by being prepared and expecting these things, or by laying out your expectations for them and getting their responses, you are preparing yourself for a much cleaner, much better relationship, possibly one free of the common violations. Non-payment, violations with repairs, and then violations with your right to enter, right? So a lot of these can be sidestepped right from the start just by what you do before you begin. Now, violations are gonna happen, and even though you've prepped them, excuse me, I like throwing in commercials for Diet Coke. What is it? Is it still the choice of a general next year? I don't remember. Such an old one.
Pepsi.
Pepsi.
Wrong.
Okay, well, we'll just edit that in post. Violations, they're going to happen even if you try really hard. 1 or 2 will sneak in. And so what I recommend whenever there's a violation is you definitely want to inform the tenant in writing that what they've done is unacceptable. It's not good enough to give them a call and say gently, I really wish you would pay the rent. Or, I heard you have 4 dogs. It's not enough to just call them and ask them nicely. The lease already does that. The lease is that polite forewarning of this is what's supposed to. Your sit down with them was you asking nicely to follow the terms of the lease. Once a violation occurs, you stop being nice. Now, it doesn't mean you're not polite. You're still perfectly respectable, perfectly polite, but you're not going to be nice about the threat that this violation now has on your most valuable asset. And so you're issuing a written notice and saying, you've violated X section of the lease. Please do Y to remedy it. I'll be back on Z date to confirm it. And by laying things out that well, a good tenant will say, you got me. Okay. I'm gonna fix it. I'm getting rid of sparkles. Or I'm gonna, I violated the HOA. I shouldn't have left the trash cans out for 7 days straight. I'm gonna fix that. I'm gonna go bring them back in. Won't do it again. The bad tenants, you're never gonna fix them. A bad tenant is a bad tenant. They're gonna be bad all the time. It doesn't matter how much warning you give them or how many notices you give them. They're not gonna stop. They're just not good at it, right? And so I'm this way with baseball. You can give me all the coaching you got. I'm not going to be good at that game. I watch baseball from time to time. I've seen other people do it. It looks, interesting and fun, but I can't do it. I don't have the mechanics to do it. So no matter what you tell me, no matter how hard I try, I'm going to fail at baseball every single time. So I'm not a good candidate for MLB anything. I'm just not. And so, but I gotta know that, and you gotta know that if you are the manager of a professional baseball team. Ernie's not a good pick for this particular task. And so, our tenants are that way too. If we can see that a tenant is not a good pick, then we pass them up and we go to somebody else. It's not that they're a bad person necessarily. They might just be a bad fit. However, if they genuinely want to fix things, that one written notice might fix it forever. And so it's important to send it, because if you just hope and pray that they're going to do it, they may not know it's important to you, even if they know that it's wrong. So by saying it in writing, it makes a deeper impact. And so always, always, always send written notice and then follow up. It's not enough to just point it out and say you mean to follow it up. If you don't, just like that kid who you told to clean the room and you said precisely how to do it, if you don't go check, chances are they didn't actually do it right, even after you asked them nicely, right? They didn't do it right after you got after them either. And so you got to go and you have to confirm. And if you do confirm, you say, thank you very much for getting it. I'm sure, things won't happen like this again. I appreciate you doing this, right? People like being rewarded, even with just a simple thank you, and they're likely not to do it over again. And you're likely not to create strife by not making it a contentious event. If they make it contentious, then again, that's probably an indication you're going to need to fast track them out, right? If they're contentious about the little things, they're going to get contentious about the big things. And that's when the repeated notice, you did it again, or you did some new thing wrong, I'm going to send you another notice. And then you did it again, or you did some new thing wrong, I'm going to send you another notice. And so once you've sent a number of notices, you have to ask yourself, is this tenant ever going to stop? I have so many clients who come in and say, Ernie, this guy, he's been a tenant since 2011. He's paid late 1,000 times. and naturally, I want to ask, how many notices did you deliver? How many notices default? I really got on him like 4 or 5 times. Like I let him know I was upset about this, right? But how many times? 1,000? And you didn't issue one written notice of default? And since 2011, you renewed every year? You're essentially telling the tenant, the thing you do, I love it. I want more of it. By not calling them on the violation and by renewing every year, you are condoning it, right?
Well, also, by sending them a notice after a notice after a notice, and you don't take any action, like sending them a vacate notice, that's just the same thing.
Yes, and I see that happen too. In fact, I see it happen where I have this conversation a lot with landlords. And they say, well, we were in the 3rd month and they didn't pay, so I got on it. I issued a notice to vacate, I filed, and then they came and paid. And so I dismissed, okay? And then in month 5, they did it again, but Ernie, I was on it. I issued a notice to vacate and I filed, but then they paid. So I dismissed. Ernie, it's month 8. You'll never guess what happened. And, you had all the signs in month 3. If you're in month 3 and they're already violating, that's a terrible sign. Terrible. But by condoning it and by just going along and saying, you can pay whenever, and the worst is when they say, but they never paid me those late fees. Can I get those now? I said, no, you can't. You waived them. You waived them by being
Nice.
too nice. Too nice. And accepting them even though they failed once and twice and now they're here. And you're thinking about forgiving them again if they pay. That's bad thinking. When somebody is repeatedly violating the lease in this way and you condone it or you forgive them, you're essentially telling them, I'm cool with this. I'm cool with you not paying your late fees, even though I had to go all the way to the court. And didn't I lose money when I paid those court fees? I guess I did. And didn't I lose time and effort the 45 times I called and texted and emailed you? I guess I did. But somehow, when the money is presented, it all goes away. Like everything is right again, right? The rainbows appear, and the birds are singing. And I'm like, yes, I'll take it. It reminds me of that woman who doesn't leave that man, and all her friends see it. They all tell her he's no good for you, but she's so in love with him because that one time he brought her flowers. And so she forgives everything, even though we all know what's going to happen. Within another month or so, he's going to mess up again. And then it's just a pattern, right? And so we sometimes get in those same patterns with our tenants because we would prefer, number one, to avoid conflict. That's a big thing. Most landlords are so conflict averse, they'll do anything to avoid it. They'll neglect so much if it means they don't have to say something or have a complicated conversation with somebody or have to knock on the door. No, I'm leaving. And they won't even wait for the door to be answered because they can't face their tenant. They don't know what to say. They don't know how to do it. Now, in a lot of ways, that's why I have work. Bless you. In a lot of ways, it's why I work because sometimes a landlord just can't do it. Like they can't stomach. It's too hard. But I would say if you do it once, you do it just once, I guarantee you the second time it's a little easier. And after a while, you're just gonna get good at it. And you're like, yes, notice. And it's just gonna be very easy. Not that you should abuse that, certainly, but if it's happening, you must address it. And it will make your situation better, I guarantee it. So,
I want to share something very small. I had a tenant for 36 months. He was a good tenant, but he always paid late. So even it was on Sunday, on the 5th, I go with my notice. And they always pay me with late fee, on the 10, but they knew that every single month they were late, they had the notice. And so I never had to file the eviction, but they always pay me the late fee.
you know what they were indicating to you?
What?
You know what they were indicating to you?
What?
Your rent was too low.
Oh. Okay, yeah.
If a tenant is willing to continually pay those late fees, that means they got so much money lying around.
Yeah.
Just so much. Help them. Ease their burden. They're carrying too much money. Raise the rent and watch them stop doing that.
Yeah.
Right? If your rent is $1,500 and they're paying you 12% on top of that, so about $170, $180 extra dollars, then that tells me at month 13, they can afford $1,700. And if they keep paying the fees and now they're paying about $1,900, guess what? Month 25, now they're paying $1,900. They've got the money to pay it. Meet them where they are.
Yeah.
Right? Then just say, you know what? I'm with you. I love collecting these fees. You love paying them? I love collecting them. But now we're going to make it rent. So now you're obligated to pay it.
Yeah.
Now, again, you can't do it during the term.
No, of
But
course.
certainly if you're going to renew, that rent should go up because ultimately your late fees should be prohibitive. If they're not, because your rent's too low. Rent's too low.
Sounds good.
Yeah. Yes, ma'am.
I have a question. When they send the list, they said that they had 2 children, right? The parents had 2 children. Then slowly.
You always want to call your tenants on any violation, and certainly unauthorized occupants is a big violation that happens all the
Should I put
time.
the list on the list?
Yes. So I think it's section 12 in the Texas Realtors lease that talks about the occupants. And that section is sometimes, unfortunately, left very blank. Even though we know as landlords, well, we have tenant A and tenant B, mom and dad, but we don't mention the children. You should. You should mention the children by name and their ages in parentheses. That way you know mom and dad, and then the children, one's 2 years old, one's 4 years old, and one's 6 years old, so that if later you see within the same year a 15-year-old, a 21-year-old, and a 19-year-old, that's not right. It's not the same people.
So I have to wait until the lease is reviewed, right? At the time, so I can reverse the lease, or I can reverse this way.
So if they are in violation, if they have people who are there who are not allowed to be
Yeah,
there.
every time I see them, they said, "Hey, you are lucky. Our family reunion weekend."
Yeah.
Did you
Yes.
put in the lease though? You have a lease with the tenant section in it?
So,
And know the actual people there.
yeah, if number one, if they are legitimate guests, temporary guests,
This say so.
okay. But if they've
Come
been there
here on
for-
weekend, come here this afternoon. They will become, tonight. I can't just sit there and watch them, right?
You can't, but it is a complicated situation. If you had a ring cam on your door,
We didn't have.
but what I'm saying is if you did,
Yeah,
and you saw 25 people come in,
Yeah.
and only 3 people went out, right? You know, hey, I've got evidence that there are 22 people living here, probably, maybe more, I don't know, but you have to be able to point to something as evidence of it. Now, sometimes that evidence is clear in an inspection.
Okay.
For example, if you have a 4-bedroom home,
Yeah.
right? You have a 4-bedroom home and you have 4 tenants.
I have 10 tenants there.
Right, so if you go and you see clearly
Yeah.
there are a lot of people there and each of the bedrooms has clearly multiple people.
Yeah, because of my contract,
You know how else you could find out? Your neighbors.
the neighbors. Oh, neighbors hate them so much.
Neighbors are really good. You always want to make at least one neighbor friend of all of your rent houses because your neighbors will
Yeah, they are the free place.
they will call out bad tenants.
Studio worker.
Yeah, and so
Actually,
Right.
because they'll get to know them, and especially if they stay on the property a lot, right? Maybe a housewife or a retired
Yeah,
person.
yeah.
They're there and they see and like, I know. I talk to them. Hey, how's it going? Da, 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 da. Oh, yeah, man, you got a lot of people here. How many people? Oh, 12. Wow, that's a lot. Okay, good talking to you. And so you don't ever want to let the tenant know where you got your info, but you can send a notice and say, look, I know you have people living here who are not. You don't have to know their names. I wouldn't. No. Not a matter of increasing rent. It's a matter of saying, if you don't get rid of them, I will be forced to evict you.
Oh, okay.
Now they might come to you and say, please let us keep them.
Yeah, it's
We'll
yeah.
even pay more rent. And then you can decide whether that makes sense for you. You may say, well, I need to go and check out and see what's going on.
Okay.
Because if it's overcrowded or you see damage already
Yeah.
being
yeah,
caused,
people.
that should be a no. It should be, look, you've already caused damage. That's another violation. No, you either got to get down to the people who are on this lease, or all of you have to leave.
Okay, I see. Just
And so, but
evacuation.
you're issuing notice. You're issuing notice, and if they don't change anything, then you issue ultimately a notice to vacate, and you remove them from the property.
Thank you.
Yes, you're very welcome. But that's the same with all violations, right? Anything that threatens the value of your home should be taken so seriously that you're issuing notice, that you're following up, and that ultimately, when it comes to it, you are beginning the eviction process. So for those of you who have never done this, the eviction process requires notice, and then it requires a filing in the justice court where the property was located. So if you're in Harris County, for example, there are 8 precincts in Harris County, and so each precinct has 2 courts. I'm closer to this courthouse. And sometimes it's worth the drive to go to another because maybe that particular courthouse is full of cases and another courthouse is much speedier. Sometimes there are other factors that make different courthouses more favorable for landlords than they are for tenants. And so
I thought that you have to file in the address. It was corresponding to the precinct.
yes, so again, in Harris County, there are 8 precincts, but in each precinct, there are 2 different courts. So for example, right here, this is probably precinct 4, which stretches from the outer edges of Katy all the way to Humble and Kingwood. So it's a huge precinct. And so you might have a case in Humble that you want to bring to the Cypresswood court that's closer here, or vice versa, right? depending on your situation. And so
you can file close to your house or close to the property.
if that court is better suited for you, I would recommend that, yes. And so as long as it's within the precinct, you don't have to go necessarily to the one closest to the rent house. You want to go within that precinct, but if you can choose between the two courts, sometimes there is a more favorable selection. And so, but you have to know that. You have to know not only that there are two courts in your precinct, and that's not true in every county. Some counties have that, some counties don't. But certainly in Houston, or in Harris County, that's the case. But yeah, you want to know where you're going. You want to know that it's the best place for you. The other thing is knowing how to fill out that form. Sometimes landlords. Sometimes landlords have this misconception about the form itself. For example, one common error that landlords face when filling out their eviction form is they say, well, this lease has expired, so I have no lease. And they begin filling out their form as though there is no lease. But that's not true. The fact that it has lapsed into a month-to-month agreement doesn't change the fact that you still have a written lease. And that last signed version of the lease is still controlling for purposes of notice, for purposes of the parties who are involved. And so it's important for you to keep track of it. Don't just toss out the lease because it has expired. If it has not terminated, it is still the optimal lease, and it's the one you will likely have to present at court if asked by the judge. So make sure you understand that concept. The second thing that landlords sometimes get wrong has to do with counting to 3. You would not believe how many landlords get this wrong, but that 3-day notice works in a very specific way where the courts are involved. So I want to go through this with you. So let's presume this is my 3-day notice. And Daniel, I'm handing you a notice to evict. You gotta leave that table in 3 days. So here's me handing the notice to you. Here you go, notice to vacate. Awesome. So by state law, I have properly delivered notice because he is the tenant on the lease and I personally put it in his hand, right? Well, we're not gonna get into the various ways that can be messed up, but that was proper delivery. We always send our notices by regular and certified mail. We have found that has always done the job for us. Even personally delivered has failed in court. I've seen it, believe it or not. But in this case, I delivered the notice. So if today is Thursday,
Yeah,
when can I file?
Monday.
Let's do the count. So today is Thursday,
Yeah,
Friday is day 1,
yeah,
Saturday is day 2, Sunday is day 3. Can you count the weekend?
No.
yeah. Why not?
No, I didn't think
Because, but we can't, the leasing, right, by weekend, every day.
Don't yell at me, yell at him.
She will collect the more than the fee.
He is the law. But I would say Wednesday.
Wednesday.
Wednesday?
Monday was right. You do count the
See?
weekend.
Yeah.
You
because
do count
she
the
collect
weekend.
the little fee, but every day.
Now naturally, if Monday were a holiday and the court would be closed on a holiday, naturally you can't go into the court, so you would go the next business day. But yes, all calendar days count. And so you can file on the next available business day. Now let's say it were Tuesday. You issue the notice. Tuesday is day 0. Tuesday does not count. So then Wednesday, Thursday, Friday, and so Saturday, you go to the court and it's closed. So you have to wait until Monday.
So
right?
effectively is in number 4. So you have to wait 3 days and 5 in number 4.
3 complete days. Too many landlords assume that the clock starts ticking as soon as they hand it to somebody. But how could you possibly prove the hour to the court? Right? That's nearly impossible. So I delivered it to Daniel at 2 o'clock, so I waited until 2:30, 72 hours later. That's not the math, and the court is not going to entertain that. And in fact, the property code spells it out very explicitly. The date of delivery does not count. So we call that day 0. All right? So that's a real day. Day 0 is the date of delivery. Then 1, 2, 3 full days, midnight to midnight. 1, 2, 3. I see so many landlords who put in their notice, I'm giving you the notice on Thursday, Sunday by 5 o'clock, you gotta go. And so they think, nailed it. I gave it to them day 0, then they got Friday, they got Saturday, they got Sunday by 5 p.m., thinking that somehow that's a full day because that's when businesses close, or I don't know. And even if it had been a work day, even if it had been Monday, for example, by 5 p.m., if that were day 3, you just ruined the day because it didn't go midnight to midnight. So don't cut things off. Learn how to count. Day 0, 1, 2, 3, day 4 or after, you're in the clear. And also don't put 5 o'clock in your notice. It doesn't help. In fact, the law doesn't require you to put an end date. It doesn't require you to count. It doesn't require you to tell them when this notice is effective. It just says give them 3 days. Because I've seen landlords who have that defect in their lease where they said 5 p.m. on the 3rd day. They actually waited 10 days before they filed. But guess what? Because the notice was defective, the judge said, I'm kicking it out. Do you happen to have a valid notice for me to review? And of course there is none. But Your Honor, I waited 10 days. I didn't even honor my own agreement. That's right. You didn't honor your own agreement, which required you to give them 3 days. What you gave them was 2 and most of a third, which doesn't count. And because you didn't follow the rules, don't expect the court to help you when you are in breach, right? We get this sense that, well, it's unfair. Why would the judge, well, I did most of it correct, but we are not holding our tenants to that. We're holding tenants to, you gotta do it all right, and if you don't, I can evict. Well, the court's going to say, you have to do yours all right, or else I'm not signing that judgment. And so it's important for us to know how, number 1, what kind of lease we have, number 2, how to count to 3, and then number 3, how to calculate unpaid rent. Unpaid rent. Most people know this, but some do not, especially if you've never filed before. When you file an eviction, you cannot claim any costs that are not rent. For example, pet fees, HOA violations, late fees, unpaid deposits, which sometimes happens.
What if it's rent, pet rent? Not pet fees, pet rent?
Yeah.
That's a great question.
Okay.
That's a great question, and I hear that a lot, and I gotta tell you, I don't like the term pet rent. You know what I do like? Just regular rent. If you and the tenant agree that there was going to be an assessment of pet rent, just add it to regular rent because the code doesn't feature anything having to do with pet rent, but man, is it real tough on regular rent. So if it's all the same between you and the tenant, just make it regular rent. The rent would have been $2,000, but there's a $150 pet rent. Let's just bump up the regular rent. We'll understand that it's pet rent because rent is non-refundable, right? But if you call it pet rent and it's not featured in the rent section of the lease, that judge might refer to it as a fee. And how do you sidestep all of that? You erase that and you add it in, and now it's just regular rent, inarguable.
What if you put the fee, because it happened to me with the employee of the court, they say me, it's just the rent, correct? And he said, you can put the fee if you want, but I don't think the judge will accept it. She told
Well,
me.
First, don't ever take legal advice from the clerks. I've had so many cases where somebody says, but she said that's what I was supposed to, she said I was supposed to.
No, I understand. Now I understand that it was wrong, but what happened, can she dismiss the...
Because you included it?
Uh-huh.
No.
Okay.
No, that's not a basis for dismissal. It is a basis for confusion though.
Okay.
And sometimes it'll confuse the court as to, what exactly are you asking for here? And if you can't clearly explain to the court how much of your claim is explicitly rent, you might not get as high a judgment as you want. In fact, the court might get frustrated. I've seen this happen with people with terrible, terrible rent ledgers. They show up and like, you ever seen those movies where someone's doing all these calculations in their head and these formulas are flying by? The court doesn't do that. As soon as formulas start, nope, shutting it down. I'll give you possession, but you're not getting any rent. I've seen it happen. So if it's too complicated, a lot of times the court, I've got too many cases to deal with here. I'm not gonna sit and whip out a calculator and figure out your stuff. You should have figured it out. So knowing ahead of time that those kinds of things are excluded, that the only thing you can get is rent, if it's very simple, $2,000, $2,000, $2,000, the math is very easy for the judge and you're likelier to get what you're asking for. Now, another truth is, sometimes, particularly new landlords will ask, well, Ernie, I filed in June and they owed me all of May and they owed me all of June, but my trial is July 7th. Do I have to issue a new notice for the month of July? Do I have to issue a new petition for the month of July? And the answer is no. The month of July is anticipated. And so at trial, you will present evidence of non-payment for May, evidence of non-payment for June, and evidence of non-payment for July, and most courts are going to limit you to those 7 days. So go ready with a calculation of unpaid rent for those 7 days. Some judges will give you the whole month, but many will ask you to prorate it through the date of trial. So be ready for both.
I have a question.
Yeah.
How much is for the trial? How much it costs the legal fee is for the trial?
You're talking about the filing fee?
No.
Lawyer
Because, the lawyer fee, the attorney fee.
Well, it's going to depend on what lawyer you hire. If you hire the law office of Ernie Garcia, we charge we bill on an hourly basis. And we ask for a $1,500 retainer plus the filing fee, which is generally $135 for one tenant. In Harris County, it's $75 for each additional tenant.
How about if the tenant want to go to trial?
Well, if the matter goes to trial, so our fee includes notice, the petition itself, we'll file it, we'll prepare for trial and attend trial.
And tenant try to scare me, said if we are going to trial and the jury always stand on tenant's side.
What it does do, especially if you have counsel, it makes it much more expensive. Because a bench trial can be over in 5 minutes, whereas a jury trial is going to take at least 3 to 4 hours.
Okay.
Right, because-
if I go to the jury trial, should I go by myself or I have to have a counselor stand with me?
So if you're asking, must you have an attorney? The answer is no.
No.
You can go all the way to the Texas
myself.
Supreme Court by yourself.
Okay.
Nothing in the law requires you
Okay.
to have an attorney necessarily. Some cases where you have an entity like an LLC
Yep.
or a corporation,
That's a whole-
those can get a little more complicated in
that's
higher
another.
courts. But in the justice court, you can do everything.
Okay.
It's designed that way for you.
Ernie, excuse me, when you say 1,500 retention is a minimum payment or?
No, so we presume it'll be about that much for all of our hourly billing. So I don't do 100% of the work, so we have other staff and we break up the tasks along the way. Sometimes the tenant, after they get notice, start packing. They don't leave, so we have to file, and then the constable comes and they deliver the eviction notice and they're like, all right, we're out of here. We're not gonna do this. So they pack up and they leave. And sometimes the landlord says, I'm good. I don't care about this judgment. They're never gonna pay it anyway. Let's just wrap it up and we issue a refund. So that the amounts that we don't use, will issue back to the landlord. They can go rehab the property, put it back on the market, get another tenant in there. However, sometimes we go all the way to judgment and the tenant appeals. And so it's inevitably going to be more cost depending on how long the tenant keeps going. But the good thing about an appeal is we always set up an appeal where the tenant is required to pay some amount into the court's registry, or at least we try very hard to get it. Not every judge will go along with this, but about 90% of the judges will, where the tenant is required to pay into the court's registry if they plan to stay. If they don't pay, we jump on that because the rules allow us to get an immediate writ of possession. But many landlords just don't know these small rules. In fact, in one court, there's no way for the landlord to get that writ from the justice of the peace unless they know that you have to e-file it the night before. This is what I found out. So someone came to me and said the payment was due yesterday by 4:30. She didn't make the payment. But when I went the following morning, the clerk said, I already shipped it downtown. So the court no longer has power to issue the writ of possession. And she says, well, I'm here at 9 in the morning. The court, no, it was 8 in the morning. The court just opened the doors. Well, that clerk gets here at 7 and she wraps up all the cases and sends them downtown. And she was in disbelief. So because we knew this about the court, we warned the next landlord and said, you need to get this tonight. We need to e-file it tonight because by tomorrow morning, it's dead. Sure enough, we e-filed it that night. The next morning when Linda or whoever she was got there, she said, oh, I got an e-file. Oh, it's a writ. I'll prepare it. And we got the property back. And she did send it downtown, and that typically happens. The appeal will continue. But the landlord is entitled to possession if the tenant doesn't pay, right? But you have to be on top of it and you have to request that writ within the tiniest window. Some courts take 3 days to send it downtown, some do it same day. This court does it in the early morning before anybody can get the writ, which I think is very unfair, right? Because they don't publish this information. We knew it because a prior tenant got burnt, prior landlord got burned and couldn't get there, even though they were there, just like I tell them, you go the next day as the court opens, and it didn't work for them because of the way that they do things.
I asked you last year when you did the presentation for evictions and stuff, and about the notice 30-day period for some federally backed mortgages that they require 30 days. And last year you were like, yeah, this is a pandemic thing, and it's still kind of marking you like it's not like a straightforward answer. Do you have any clarification about that this year? Is it a little bit more clear, or it's still kind of some judges are taking it in one way and some judges are taking it another way?
That's it. Some judges acknowledge it and other judges don't. So because of that, we advise all of our clients who have a federally backed loan, and certainly if you accept federal fundings, Section 8 housing, you gotta give 30 days. Because the CARES Act that was signed in March of 2020 in response to the pandemic, the CARES Act had a provision that stopped all evictions, right? But that provision had a sunset clause, which said this will only last until this date. That date came, it went, and then the CDC kicked in with its own eviction moratorium that ultimately the Supreme Court said unconstitutional, and so now that's going. But the part about the 30-day notice didn't have what's called a sunset provision. And so since the law was never repealed, the law is still on the books. So it's like you hear that law from 1855 is still a good law. That's what's happening with this law. Now, not all Texas courts acknowledge it, but I guarantee you the more tenant-friendly courts, those of which who have legal aid attorneys not quite on staff, but they never leave the courtroom, they're gonna use that every single time. And they're gonna ask the question, do you have a federally backed loan? No, because I can check a database and that information is available. And if it turns out you didn't give a 30-day notice to vacate and you have a federally backed loan, and certainly if you take Section 8 housing or accept any kind of federal funding for housing, you must give a 30-day notice to vacate, whether it's for non-payment or even a non-rent violation. 30 days notice to vacate is required in those limited circumstances. Yes.
I had a tenant that she had different violation, so I give her the 30 days notice. And she paid the rent the next month. He didn't pay the rent. So I put the 3 days notice. So I have now 2 notices. The 3-day notice plus the 30 days notice, and I filed eviction. It is correct or it's not valid?
There's nothing automatic that says your notice, it doesn't just disappear, right? And so the question is, if you present that notice and she says, but she accepted rent after she gave that notice, Your Honor. And if the judge says, did you issue new notice? Yes, I did. Was it also 30 days? No.
No, it was 3-day notice plus multiple violation. I put for no paying the rent and multiple violation.
Do you have a federally backed loan on your house? A Freddie Mac or Fannie Mae?
Yes.
Then you have you receive federal funding or federal assistance
Yes.
for your mortgage.
Okay.
You gotta give 30 days. Every notice to vacate must have 30 days.
Okay, but the first 30 days, it doesn't count?
So between me and you, I wouldn't talk about the second notice.
Okay.
Because I don't know that it's valid.
Okay.
But because you did give a 30-day notice, and when you show up to court, there will be a unpaid rent balance, you should win your case. Unless she raises this issue and says, Your Honor, I believe the notice to vacate, and this is a pretty sophisticated argument, I believe the original notice to vacate is invalid because she accepted rent and therefore waived the notice. I've never heard a tenant make that argument, but I have heard attorneys make those arguments. And if she does show up, and if she does get a legal aid attorney, that's the argument they could make. They're not all as sharp as I am, but some of them are a little sharper. And so, if she shows up and she has an attorney, get ready to enter into a settlement agreement. Say, look, I want you gone. How quickly can you go? Let's see if we can work out a deal. Where I still win, maybe I'll dismiss the case, but you leave. And so if she shows up with nobody, or she doesn't show up at all, which is the case 80 to 90% of the time, then go get your judgment. Don't talk about that second notice.
Can
Okay, thank you for that.
Yeah.
Can she bring a check to the jury and tell her like, hey, I got the rent for this next month, but I'm not sure if I should accept it or not in order to don't damage that notice?
I'm going to talk a little bit about a scenario similar to that. But I wouldn't go, remember, we always want to keep it simple for the court. The judge is going to ask you, how much in unpaid rent? Just give a number.
Okay.
If he asks how many months are unpaid, 2 months, Your Honor.
It's just 1 month because what's happening, my first 30 days, it was not for rent, it was for multiple violation. Because she owned a fee, the moving fee, she didn't bring the
Again, the problem is, if that notice didn't mention non-payment of rent,
in the first one, no.
and again, I'm telling you it's defective.
Yeah.
And so because it doesn't mention non-payment of rent, are you allowed to mention non-payment of rent in the petition? Not based on that notice. Now, she has to call you on it, or her attorney has to call you on it, someone has to call you on it. If you're already set for trial, it's too late to fix it. I would say, go to trial and say, Your Honor, we're here for multiple lease violations, but there is unpaid rent for the month of June
Okay.
and for 2 days in July.
Okay.
And so they ask how much in unpaid rent, whatever that number is, and be prepared to talk about
Makes
it,
sense.
right? Don't give all the details and say, well, Your Honor, see, here's what really happened. If I were your attorney, I would say, zip it, don't say anything.
Okay.
We're just gonna say numbers and dates, that's all we're gonna say.
Perfect.
And
Yeah.
yeah.
Thank you.
Yes.
How can we go after people abandon the property? We are already 2 months no pay, and I say, I'll go to evict you.
So, do you have the Texas Realtors lease?
Yes,
Okay. In the Texas Realtors lease, there is a move-out provision. And it talks about certain situations near the end. One of them is surrender. So surrender is when they say we're leaving, or you say I'm terminating and the lease ends, or the lease just ends and they say we're leaving, and they turn in the keys and they've taken their stuff. That's textbook surrender. So the next section is the abandonment provision. And what abandonment says is, if in the reasonable opinion of the landlord, you have left, and if you're in breach for non-payment of rent, and if I have given you a written notice of at least 48 hours that I consider the unit abandoned and you haven't come and gotten the stuff, then I can just throw it all away. So read that section of your lease and leave that notice. What I recommend is you take that notice and you post it on the inside of the main entry door. And if you have an email address, you email it to them. And if you have a text, you can text them. If you got them on WhatsApp, you know what? If you can throw it far enough and reach them wherever they are, find every possible way to get that notice to them. And if you don't hear back from them in 48 hours, throw it all away.
I went to the house, the door is not locked. I go to inside, I stick the notice that, and I find out everybody already left.
But they left their stuff.
Yes.
So I recommend leave a 48-hour notice. And again, day 0, don't count today. So if you leave it tonight, Friday, Saturday, Sunday, go in there and clean it out. You can throw it all away, but make a diligent effort. And the reason you want to do all this is because you don't want them later, maybe 6, 7 months down the line, and say, oh, my grandmother's $45,000 pendant, you threw it away? Oh, I was gonna go get it. I left it there in that beaten up little drawer or the thingy, and you want to be able to show the court, no you didn't, you threw it away.
I took pictures of the
I followed the lease, I left this notice, I waited more than 48 hours.
Yes.
When I came back, you hadn't reached me, I had no way to contact you, but the lease says I can do this, and I threw it all away.
Yep.
You might even walk in wearing the pendant. Like, I don't know what you're talking about, but whatever it is you're trying to explain, it doesn't matter because it's trash. The moment they abandoned it, they lost title to it, so they can't claim it. And so you want to follow that rule because they agree to it in the lease. And once you give them the notice and you wait and you make a diligent effort to contact them, they don't have an argument.
My question is, they already gone. I don't know where to in touch with them. I hope that email still have it. And obviously he doesn't want to communicate with the text anymore. So how can I still go to file as eviction, or
No.
what kind I can file?
You can't file an eviction because they're gone.
Yeah.
And so eviction doesn't work. You would have to file a civil claim, and you really have to ask yourself, does it make sense to go after people like this? Do they have the money, and can you locate them? If you can't find them, you can't sue them. And if you can find them, and you can sue them, but they don't have money, then you can't collect. And so that's the next thing I'm going to talk about. But first I want to address something that you brought up, because I had this happen before. You have a situation where you're at day 7, the tenant hasn't paid, you issue a notice to vacate. They don't leave. So after the 3 days have passed, you go and file the eviction. Let's say we're at the 15th of the month and we file the eviction. Well, on the 17th, they deposit the rent and late fees into the landlord's account. What can you do?
Refund it.
No. Never, ever, 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 ever refund it. Hold it. And you take it with you to the trial.
What do you mean hold it? You still have it in your account?
Yeah, I mean, you don't need to put it in a bag or anything. Just, you're holding it, you're not gonna spend it,
Not spending.
right?
Yes.
And so you're gonna show up to the court and say, Your Honor, I have a claim against this person. And let's say we're at trial on the last day of the month. So we filed on the 15th and somehow we got on the 30th day of the month. So you can't ask for the next month. It appears they've paid everything,
Yeah.
right? You're biting your nails like, what do I do? And you say, Your Honor, I'm here because the tenant failed to pay rent. I issued a notice to vacate, they failed to vacate. I filed this lawsuit, and then they later deposited the money in my account. I am willing, Your Honor, if I can get rid of this tenant, I am willing to issue a refund of this money if you require that of me. Otherwise, I would like a judgment, and I'll take a $0 judgment, but a judgment for possession. I am here to follow whatever you order me to do. Either way, I want an eviction. And you let the judge make that decision. And 9 times out of 10, the judge will say, that's your money. They paid it late, they didn't follow the rules, I will sign the eviction. You'll get $0 in rent because they've paid through the month of June, but I will evict them. 1 out of 10 judges will say, well, this doesn't seem fair. They paid the rent and late fees and you want to evict them? The only way I'll sign this eviction is if you will return the money. And you say, gladly, Your Honor. I have a check right here, I'll write it to them. Or that 1 out of 10 judge will say, you have not been injured, I will not issue an eviction in this case. I think that judge gets it the most wrong because you were injured. At the time you issued the notice to vacate, you had what Chapter 24 of the Property Code defines as a superior right of possession because they were in violation. So you can only ever request a notice to vacate if you have a superior right to possession. So you did it, and you gave them an opportunity to leave, and they didn't leave. Then you filed, and then you did everything you were supposed to do. They tried to make up for it, but there's a default in the lease they didn't make up for. They weren't guilty of non-payment, they were guilty still of not doing timely payment. And that should be the default that wins the day. But not every judge will agree. So these situations are rare. These situations where usually what happens is you lapse into the 2nd month, and the 2nd month there is no payment. So you go into the court and say, Your Honor, this is what we still have a balance of unpaid rent for this amount, which is a few days in the next month. Say that's all I want in my judgment. That's all I want. Okay, they didn't pay it. You get to get it. Here you go. You get a judgment for these number of days and possession. But I've had it happen where, it's so close and the tenant thinks they're going to pull one over. And I always advise the client, don't send the money back. Because if you send the money back, you could get that 1 out of 10 judge that says, they paid you. If you didn't want the money, that's on you. I'm dismissing this case anyway.
Oh my God.
Yeah, you don't want to be in that position.
What's happening if they do partial payments?
So what I always tell landlords is this. You do the same thing. They do a partial payment, just deposit it. You never solicited it. You had already filed the eviction. You go to the court with those partial payments. You say, Your Honor, I'll give credit for this, but I don't want this to invalidate my eviction. If you're saying I have to return it to get my eviction, I will do that. I'm prepared to issue a refund if it means I get my property back. I am that serious. And typically the court's gonna say, no, you can keep that, you're entitled to that. Again, 90% of the time, the court's gonna make a proper ruling and say, that's your money, it was your money the moment you got it.
And what about the deposit?
What do you mean?
The deposit?
Security
The
deposit.
security.
Oh, that doesn't even come into question yet. You have 30 days from the day they leave. If they're still there, you're not even talking about the deposit. Yeah, no, it's premature to talk about deposits if they're still on the property.
What if I go to the court and she say, okay, I have the 30-day, I say I give the 30-day notice, but she say, I also have a 3-day notice.
Your Honor, I gave extra notice, hoping that we could fix it, but she didn't.
Okay.
Again, I don't want you to talk about that second notice. If she brings it up, you say, because the code actually does allow you to give subsequent notice. She says, I'm relying on the first notice.
Okay.
Yeah.
Sounds good.
When can you start to file a writ of possession? Do you have to wait or you can file right after the hearing date?
So typically the court doesn't have authority to give more than 6 days. But that judge, again, making up their own rules,
Yeah.
and gave 14 days.
Yeah.
The problem with that is that the rule says on day 6 you are eligible to get a writ. But the judge's order might say you're not eligible for a writ until day 15. And so that judgment usually has a line that says plaintiff wins $1,500 in unpaid rent and may obtain a writ of possession no sooner than, and they put in a date. So on that date or after, you can get your writ of possession, but not before.
Yeah.
So if the judge gives them more time, I mean, he's the judge or she's the judge.
But what happened? They not live right on the day that the judge ordered.
Then you get the writ. Then the first day if the writ is available, you purchase the writ.
I asked the sheriff there, they say, well, you can file this another $120.
We tell landlords, when you purchase a writ, you can expect to wait another 2 to 3 weeks before it is exercised. In some parts of the year, especially around the holidays, it can be much longer. Even after you win,
Yeah.
you could wait as much as a month.
Yeah, like 2 months.
We never get our money back. No, never.
But remember, in many cases, the thing you get back is that valuable asset. And yeah,
that's
you got a bad tenant, you want to get rid of them because
Yeah.
they're harming your asset. And so you get back your baby, that's all that matters. If you can get money, great.
Right.
But most of the times in that situation, you can't get money. And so you want to do your best to get them out as fast as possible
Yes.
and minimize your loss. If you can recover your losses from the security deposit, great. But that's not always possible.
Yeah.
But what is always possible is you'll get your property back and you'll learn a few things from those experiences, and hopefully you don't get anything bad from a future tenant. I do have one last thing I want to talk about, and I know I'm beyond my time, but for those of you who have judgments, if you have not abstracted your judgments, you're leaving money on the table. An abstractive judgment is a simple thing. You make a request to the court and you tell the court, I have a judgment against Joe Smith. And Joe Smith, because I have his application, has a birthday on this date. The last 3 of his social are these 3, and the last 3 of his driver's license are these 3. I would like to request an abstractive judgment, and the court will issue an abstract. If you have any amount that Joe Smith paid toward the judgment, you have to give him credit for it. But if it's 0, then you're asking for the full judgment. But you need the defendant's date of birth, the last 3 of their social, and the last 3 of their driver's license or ID. With that, now you take that abstract, which is signed by the court, and then you go to the property clerk's office. And the same place where you file your deeds and your liens, now you're gonna create a judgment lien. You're gonna file that for like $18, $20, depending on your county. Right, you're gonna file that 1-page document, and now that Joe Smith, with that specific birthday and those last 3 of his social and those last 3 of his driver's license, he's gonna have that judgment on his credit report. And let's say 7 years down the line, that Joe Smith wants to buy a house. Guess what the title company is gonna find? Joe, did you know you had this judgment against you from 7 years ago? It says it's $3,000. You need to pay this off before the bank's gonna loan you any money. You have to clear this judgment lien. And then guess who gets a phone call? You do. How can we release this lien? Well, let me whip out my calculator. If Joe now owes interest, $3,000 turned into $3,811. Joe sends me that money, I'll release the lien. A lot of times, you'll get a check from the title company because they're holding Joe's money, right? Because he sold his house, right? And there's a lien there, and it's your lien. They're holding Joe's money. You'll get a check from the title company. They'll send you a form that says release of lien. You sign it in front of a notary. You send it back to them. And Joe gets to get the balance, but you get your judgment. If you have not abstracted each of the judgments that you've got in any Texas court, I strongly recommend that you do it. It costs just a few dollars from the court itself, and then you got to know how to go file it with the county clerk's office. And you gotta have those three pieces of information: date of birth, last three of the social, last three of the driver's license. But it is an invaluable tool. If you need help, that's a service we offer. We charge $300. We do everything for you. We get it from the court. We file it with the proper county clerk. But this is something that every single one of you can do and should do. If you've got one judgment or you got 10 judgments from all of your years, gather them up and go record them.
What if you don't have the social security?
You should have, with the application, you have the.
Get as much information on there as you possibly can. If you have the driver's license, then you have the date of birth and the last three of the driver's license. Sometimes, if they have a passport, you can identify them with the
I
last
have
three.
the ID, I always ask for the ID, but I don't ask the social security.
It should be one of the features in your application, because how else are you running a credit check?
They do.
Oh, they do it online. That's one of the drawbacks of not going old school, right? And so if you can get that somehow from each of your future tenants, I would get it. Here's another trick. If they have a checking account, ask that they pay the deposit through their checking account, or they pay something through their checking account. You always want to know if they have a valid checking account, because guess what? If ever you win a judgment, you can attach and freeze that account to pull whatever money that's in your judgment from that account.
So they have to give you the full checking account, because if they do electronic transfers, for example, it doesn't count.
Again, they don't have to do anything, but if there's money in there and there's enough to cover your judgment, guess what? You can get that
No,
money.
I understand, but when you receive the transfer, the sale or whatever, you don't get the full number account.
No, but you can ask them in your application process if they have a checking account, if they have a savings account, and what are those numbers at what institution. So these are helpful things that you can get. I appreciate all of you who were here. I don't want to keep any of you longer, because I could just go for a while now. But I do want to thank you all very much.
Thank you so much.
You're very welcome.